Good morning, everyone, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every Sunday from 8 to 9 a.m. on these stations to bring landowners valuable information that you need regarding natural gas development here in Pennsylvania. And if you're looking for the show for landowners, then this is the radio show for you. At the Clark Law Firm, my focus is solely on landowner representation, not companies, not gas companies, not pipeline companies, but landowners and individuals who own their oil and gas rights. I represent people for such things as gas lease negotiations, pipeline agreements, waterline agreements, surface sites, damage release, royalty issues, doing a lot more with estate planning. I talk about that quite a bit. But anything involving the natural gas development here in Pennsylvania. And if you need representation, you can always contact me at the Clark Law Firm. Again, Doug Clark at 570-307-0702. But this show is not just a commercial. This show is meant to give you valuable information regarding natural gas development, things to think about, not designed for individual advice for any specific person, but to get you thinking, to get you understanding what's going on, whether you need representation, whether you want to learn about natural gas development, whether you're engaged in discussions and you need some information. Hopefully you'll find something here of value. Also, if today's show doesn't give you value, encourage you to check out the websites at pagasleaseattorney.com, pipelineattorney.com. I have a bunch of the prior radio shows archived, so they're available there. You can go back, listen to them at your leisure. You can also, if you missed any of today's show, well, it's early, so if you have to leave and miss any of today's show, or if you miss any of the recent shows, this is the first time listening, you can go back, pagasleaseattorney.com. We'll have this show up tomorrow, Monday morning. Give us to about 10 o'clock, and you can check out today's show. So if you can't catch the show every Sunday from 8 to 9 a.m., you can always go to pagasleaseattorney.com anytime during the week, on the weekend, at night, in the morning, whenever, and check out the radio show from the past week and other weeks as well. So, okay, I want to get in today. I'm excited about today's show. I have to say, I was away on vacation last week, so I'm energized and I'm refreshed, though I do have a bit of a cold. But today, I'm excited. I'm going to talk about pew clauses a little bit, but not in a way that you think. I'm going to talk about how they can come back at times and haunt the landowner, meaning it's not always the greatest thing. But we're going to talk about both sides of the pew clause. I'm going to talk about confidentiality agreements. And again, one of these things where we think, oh, okay, well, this is a good tool for the landowner, but I'm going to talk about how it can also be a good tool for the company. And then I think we'll have time. One of my favorite things to do, I'm going to talk about some landman tactics and probably get on a little bit of a rant about the company landmen and what they do and things that you need to be aware of as a landowner. So again, you're listening to Attorney Doug Clark. This is All Things Marcellus here every Sunday from 8 to 9 a.m. So let's get right into it. And I want to talk about the pew clause. Many people, if you go online and you do research, you're engaged in oil and gas lease negotiations. Or so you have your oil and gas lease and you don't know if you have a pew clause or you do. Or if you have a gas lease and you have a pew clause, here's something you need to be thinking about. But especially in current negotiations. You go online, you read, okay, hey, what is it that I need? What addendum terms do I need? Well, one of the top ones that you'll read about or you'll hear about is what's called a pew clause. It's spelled P-U-G-H. Well, what is a pew clause? A lot of people think they know what it is, but maybe not necessarily do know exactly what it is. And pew clauses can come in many different forms. What I call a pure pew clause would say something like this. It would mean that most leases, not all, leases are for a 5-year, what we call a primary term. That 5-year primary term is the time frame where the drilling company or the company that you've leased to, they have 5 years to conduct what are defined as operations. And operations can be many different things. They could be which doesn't seem to make sense, but it's defined that way in some leases, that operations could be simply filing for a drilling permit. So if the company files for a drilling permit that's going to be in a production unit that your property is located in, not necessarily, not actually, doesn't have to be on your property. If they form a production unit, let's say it's 1,000-acre unit, and your property is located in that unit, if the company files for a permit within 5 years from the date of your lease, and your lease says that that's enough to what we call hold your lease, then you will stay under lease. So you'll go into the secondary term. So again, to reset, you enter into a 5-year lease. The company has 5 years to conduct operations. Operations may be defined as simply filing for a permit, but let's make it simpler even more for our case. Say that the company, your lease says that conduct operations means that they actually have to be drilling in the unit that you're a part of. So whether it's on your property or not, and most likely it's not going to be on your property, but if you're in a unit and the company has 5 years to drill and they start drilling within that 5 years, well, your lease would be held by production, even though you're not actually getting royalties, but the company has met the definition of operations. I am attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. and talking about a pew clause. So we got our basis here. So how does a pew clause come in? Same facts. You sign a 5-year lease. You're in year 5. The company now starts drilling. In our example, we're going to say, just a nice round number, that you have a 100-acre parcel. This could be true if you had 10 acres. And I'll probably do this. We'll give 2 kind of examples throughout. One person has 100 acres. One person has 10 acres. So, okay. At the end of this 5-year term, 5 years from the date that you signed your lease, the company has formed, we're going to just call it, we're going to pick a number, nice round number, 1,000-acre unit. So the one gentleman has, or lady, 100 acres. So at the end of 5 years, there's a unit formed, and that unit only includes 50 of your 100 acres, meaning that you have 50 acres that are not included in a unit, but you have your other 50 acres are included in this unit. Now, I want to tell you too, I just picked 50 acres. We could have picked 5 acres. We could have picked 90 acres. But for our example, we're just going to say you have a 100-acre parcel and 50 are included in this unit, but 50 of your acres are not in this production unit. So a regular lease, a normal form lease that you sign with the company, or a lease that doesn't have a pew clause, a regular lease is going to say that if any of your 100 acres are included in a unit by the end of that 5-year term, then your entire 100 acres is going to continue to be held under lease. So if you have 100 acres and at the end of 5 years, only 2 of your 100 acres are in a unit, you're only going to receive royalties on the acres that are in the production unit. So even though you have 100 acres, if only 2 of your acres are in the unit, you're only going to be receiving royalties for those 2 acres. So obviously you're really disappointed as a landowner. You'd want the goal for everybody to have their property completely unitized. So you're going to be pretty upset about that. Think about it. You could have 100 acres and you only have 2 acres in the unit. Another person, a neighbor, could only have 5 acres, but all 5 of their acres are in the unit. They're going to get more royalties than you, assuming you have the same royalty percentage. But they have, more than double the acres in the unit. Even though you own 100 acres and they only own 5, you're going to see that they're going to have more royalty because they're getting royalties for 5 acres. Now, over time, we would hope, in most cases expect, that the remaining 98 acres would ultimately be added in a unit, but we're talking about pew clauses. So what's going on again? We got a 100-acre person. We're saying that 50 acres are in the unit, the other 50 acres are out of the unit. A normal lease will say all that entire property is held under the lease and you don't get any other bonuses. You just continue to go under the terms of your lease. What does a pew clause do? Okay, a pure pew clause, and I want to stress that, pure, A pure pew clause would say that end of that 5-year term, that in 5 years, if you take a look at what's going on, and in our example, 50 acres are in the unit, 50 acres are out. A pure pew clause would say at the end of that 5-year term, whatever property is not unitized, 50 acres in our case, whatever property is not unitized automatically reverts back to the landowner. So now you have 50 acres that are in a unit. The 50 acres that were not in the unit revert back to you. So now they are essentially what they are, no longer under lease. You now are essentially a free agent with those 50 acres. So that can be a very powerful tool. However, very, very big however, that can also come back to bite you. And I've seen that just happen in a very recent case that I dealt with. And you say, well, how is that the case? I read online, pew clause, pew clause, pew clause. That's what we need to have. Well, here's the situation. You need to be careful. The pew clause can be an extremely powerful tool for the landowner. Quick example. Back in 2006, landowners were signing, say, for $50 an acre. And again, these are general numbers, but let's just give this quick example. 2006, you signed for $50 an acre. Then in 5 years, and you did not have a pew clause. You had 100 acres. In 5 years, only 5 of your acres are now in a unit, 95 are not. If you had a pure pew clause, those 95 acres would revert back to you and you could enter into a new lease. Well, in 2011, we were seeing thousands of dollars per acre. And in 2006, say you signed at 12.5% royalty. Well, now maybe in 2011, the rate might have been as high as 20% or even 21%. So if you had a pew clause, those 95, a pure pew clause, those 95 acres would have reverted back to you in 2011, and you could enter into a new lease at that market price. And at 2011, that market price was very high, especially relative to 2006 when you signed your first lease. However, in 2006, very few people knew to ask for a pew clause. People just didn't know. It wasn't on their radar. Attorneys weren't dealing with this. So what happened was we saw in 2010, 11, 12, we would see companies who would form units and they would look to capture at least a portion of these larger properties, especially to hold them under their lease so that that landowner would not have the ability to enter into a new lease with any other property. And they did this because the market at the time was much higher. So it made all the sense in the world for a company to go ahead and try to capture your property, to hurry up, unitize it, start drilling, capture it so the lease wouldn't expire. But if you had a pure pew clause, if they didn't hold or capture all of your property, whatever was not unitized at the expiration of your 5-year term, that would revert back to you and you could enter into a new lease. However, we did not see very many cases where people had pew clauses before 2008. Then we start seeing, as leases become negotiated, more and more pew clauses. However, not all pew clauses are pure pew clauses. Some will say at the end of that 5-year primary term or the end of that 5-year term, if I have 100 acres and you've only unitized 50, the company has, say, 3 more years. They give you, it's a modified pew. So instead of the property immediately reverting back to you that's not in a unit, the company would have 3 more years to unitize the rest. And then in 3 years, if they didn't unitize all of your property, what wasn't unitized would come back to you. Okay, I'm up against it. Now I'm going to talk about, you say, well, geez, I really would like to have a pew clause. That makes all the sense in the world. Sounds great. Yes, it can be an extremely valuable tool for the landowner. However, I'm going to tell you now, how the pew clause can come back to bite you. And you need to be careful, and people who are digging in on pew clauses today need to really pay attention to what I'm about to say. I am Attorney Doug Clark. This is All Things Marcellus, here every Sunday from 8 to 9 a.m., and I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, I'm here every Sunday from 8 to 9 a.m. on these stations. And if you miss any of today's show or want to check out any of the other shows, been doing the weekly radio show since August of 2010. So if you want to check out any of the other shows, go to pagasleaseattorney.com. Just want great information. Pretty proud of the site. Go to pagasleaseattorney.com, go to pipelineattorney.com. Whether you're looking for representation or information, I believe, and we get great feedback, excellent resources for landowners. Okay, talking about pew clauses, want to jump right back in it. So, as talked about in the first segment, these pew clauses can be a great tool for landowners. However, I often talk about this, where you need, as landowners and as lawyers representing landowners, you need to understand that markets change, that circumstances change, and what may have been very important in 2006, 7, 8, 9, 10, and on may not be so important today. You need to understand your market today. Real quick example. A lot of times people are saying, hey, we need to have a 5-year lease, a 5-year lease. Well, it doesn't matter how long your lease is if, whenever you're about to enter into a lease, the company is already drilling and you have a unit that you're going to be a part of essentially the day you sign. So who cares how long this lease is? You just want to make sure that you get a lease with the best compensation terms possible so you participate in the unit. All right, I don't want to get too far off track. Okay, pew clause. So I went through and I explained how a pew clause can be a very valuable tool. So real quick, if you have 100 acres and at the end of this 5-year term, you have a 5-year lease, to say, I'm going to switch up a little, you have 100 acres, say only 5 acres are in a unit, then if you have a pure pew clause, those other 95 acres revert back to you. Now, that is a very valuable tool if you had one of those pew clauses and then your lease, your 5-year term, expired, say, in 2009, 10, 11, and even into 2012. Because there was a lot of leasing activity in 2009, 10, 11, and 12. There was still what we call open leasing. There was competition. So if that property reverted back to you, then you're going to be able to enter into a lease at a much higher bonus rate and royalty percentage than what you did in your first time, the first lease. So a pure pew clause could be a very, very valuable tool and result in potentially hundreds of thousands and possibly even millions of more dollars, especially if you were able to get higher royalty percentage the next lease opportunity. So if you had a pure pew clause and 95 acres came back to you, and instead of having your original lease at 12.5%, now maybe you got 18 or 20%, that's a whole lot more money. Plus, you also would get more bonus money. Okay, so that sounds great. And you'll read out there, pew clause, pew clause, pew clause. I talk to landowners all the time now for leasing, and one of the things they say is, well, I need to get one of those pew clauses. I need to get one of those pew clauses. Unfortunately, a lot of people don't understand actually what the pew clause is. But even more importantly, many people understand a pew clause, but they do not understand that it doesn't necessarily carry the same weight today or importance that it did in 2005, 6, and 7. What do I mean by that? Well, unfortunately, I have a recent example that perfectly illustrates this point. There was a landowner. Now think, we're in 2015 now. So we have a landowner who signed a lease in 2010. And in 2010, there was an excellent leasing market in this area. And I'm not going to give exact figures, but I'm going to give figures for illustration. So let's say in 2010, that landowner, and this was a very good area, but we'll say that landowner in 2010 received $3,000 per acre bonus and also had a 20% royalty. So landowner has 100 acres and had a lease in 2010 that paid them $3,000 an acre, so that's $300,000, plus had a 20% royalty. And because the leasing market was so strong, he or she was able to negotiate a pure pew clause, saying that what you have not unitized, company, at the end of 5 years reverts back to me so I can enter into a new lease. All right, well, you entered into this lease in 2010. You're very excited. You got a great lease. Well, now fast forward, here it is 2015. Well, what's occurred? Here we are. The person has 100 acres and only, give this example, we'll say 50 acres again. 50 acres has been unitized, but the other 50 acres has not been unitized. So under a pure pew clause, that 50 acres that was not unitized automatically reverts back to the landowner, where that can be a great thing, like we talked about in the first segment, because that 50 acres is now eligible for a brand new lease, new bonus, new royalty, new opportunity. However, in this case, the market today is much, much lower than it was in 2010. So in 2010, where he could get $3,000 per acre and 20% royalty for his full 100 acres, now only 50 are unitized. The 50 reverts back to this person, and they go and say, all right, here we go. Clap your hands. We're ready to do a new lease. Company says, well, right now, we're not interested in that other 50 acres. And you say, well, how in the world is that? Company says, well, we have all the leaseholds around you. We own all the leases in your area. We know that no other company can come in and lease this property. Well, they could, but they're never going to want to because they can't develop it. So the only company that is ever going to lease your property is going to be us. And right now, we're not inclined to lease this property because we don't intend to develop your property or put a unit in your area right now. So we're just going to sit on this. Or the other thing, so the landowner says, well, geez, I have 50 acres now that are unleased. And the company says, hey, that's fine. When we're interested, if we are interested, and they probably will be, we'll come back and then we'll issue a new lease. However, you can darn well be sure that the new lease is never going to be for the same terms and conditions as far as the financial terms as the original lease. The original lease had a 20% royalty. I see today companies offering as low as the guaranteed minimum royalty of 12.5%. Many companies are offering 15% royalty in areas that are producing and are producing excellent results. Why would you see 15% royalty being offered to landowners in great areas of production and 12.5%? Because there is no competition. Because they know no other company is going to come in to lease this property. They also know you as a landowner would want to maximize your financial compensation. So if you do not enter into a lease, you're not going to get royalties. So they say, okay, landowner, we'll give you this lease at 12.5 or 15%. If you don't want to take it, fine. We just won't include your property in a unit. And that creates a very difficult situation for the landowner. So now, here we go again. The landowner had 100 acres, signed a lease in 2010. Here we are in 2015. That landowner had a pure pew clause, which said whatever is not included in the unit, whatever of my acres are not included in the unit, those remaining acres that are out of the unit come back to me. So my example, and here we are in 2015, the 5-year term is expired. 50 of the 100 acres are in the unit, so the other 50 acres goes back to the landowner. The landowner says, okay, well, I want a new lease. I'm going to get a great new bonus. I'm going to get a higher royalty percentage, or I'm going to get maybe the same royalty percentage. That's not going to happen. We're not seeing that, and we're not seeing close to that. What I'm seeing is as little as $0 bonus, maybe $500 bonus. It depends on the company. It depends on the area. But you're not seeing these $3,000 bonus, and you're certainly not seeing 20% royalties in hardly anywhere in the state. That's extremely rare to see those numbers now. So what are we seeing then? We're seeing a landowner who's scratching their head saying, boy, maybe this Pew clause wasn't such a good idea. And so what do we do in this case? We went to the company and said, hey, company, we're willing to extend the existing lease. We're willing to waive this Pew clause. We'll give it up. We don't even want it. We have no problem. We'll just stay under the lease. We don't need any more money. We don't want anything different. Let's just keep this lease intact, and we'll get rid of this Pew clause. Company says, well, no, we're not going to do that. We're going to just go ahead and let the Pew clause take effect. That 50 acres will revert back to you, and maybe we'll lease it in the future. But if we do lease it, we know this, it's never going to be at 20% royalty, and it's certainly not going to be at a real high bonus. So that landowner is saying, boy, I wish I never had a Pew clause, because that Pew clause has now cost me a lot of money. It's cost me, maybe my royalty goes from 20% to 15%, or maybe it's even worse. Maybe my royalty percent for this 50 acres that came back to me, maybe it goes all the way down to 12.5%, because the company knows there's no competition. So to summarize, if you have a Pew clause, and when your 5-year term lapses and there's a good market out there, a Pew clause can be very valuable. But if you have a Pew clause and in 5 years into the future, that Pew clause kicks in and now you're surrounded by one company, that company has no need to make a strong offer to you because they have no competition, even if it is a very productive area. So what does that mean? So here we are, 2015. You enter into a new lease. We look at, okay, where are you? Where are you in the state? I mean, geographically. If you're in the northeastern part of the state, southwestern part of the state, where are you? What is going on in your area? If you're in an area that's being developed, there's a really good chance that you don't even want a Pew clause. You have to look at this individually. I can't stress that enough. This is not individual advice. It's information to get you as a landowner thinking. So when you read things online, and this is one of the things that kills me, people read things online. Anyone can write anything online. You need to understand factually your situation. You need to understand the market, your situation, not what somebody else wrote online, and who knows when they wrote it. Who knows if they had any idea what in the world they were even talking about. And what might have been right for them certainly may not be right for you. So if you're sitting there and you're holding out and you want this Pew clause, it's so important, you've read so much about it, and the company won't give it to you. Well, you need to understand that, you know what, maybe you're fighting over the wrong thing. And that happens a lot of times. When I talk to landowners for new leases, I say, you know what, don't get hung up on that, because that's not a major point to you. You need to understand it. So you got to be very careful what you read online, and you need to understand that every situation, I don't care if it's a gas lease, a pipeline, a well site, unitization issues, every situation is specific for you. You can't get general advice. I'm giving general advice and general knowledge to get you thinking, to make sure that you understand why general advice isn't necessarily the right thing whenever you're making specific decisions. General advice is good for education and information, but you need to understand your specific situation. So a Pew clause can be an excellent, wonderful, super powerful tool for the landowner. But on the flip side, a Pew clause can, in certain circumstances, cost the landowner a lot, hundreds of thousands of dollars and even more. You need to evaluate that when you're in lease negotiations and understand, can this Pew clause actually hurt me? What do I want to include it? If I have the option of having it, do I want to include it or not? Now, there's a lot of other very detailed issues that surround this that I'm not going to get into in this show, but that's what I want you thinking about. Don't get hung up whether it's a Pew clause, the length of the term of the lease. Don't get hung up on things that you read online. Get specific legal advice. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m., and I'm going to be back again after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. If you ever need representation, you can contact me directly, 570-307-0702. Check out pagasleaseattorney.com, pipelineattorney.com. Landowner information, whether you're looking for representation or information, pagasleaseattorney.com, pipelineattorney.com. Check out archived radio shows. Have been doing the show since August of 2010. Okay, so I want to talk about confidentiality agreements. Now, I often have landowners who say, okay, well, we want to get a certain amount of money, and maybe it's more than what the company wants to offer, whether it be gas lease, pipeline, or anything. And what they say is they say, hey, we'll sign a confidentiality agreement. Well, okay, hey, that's not bad. We can do that, and we use confidentiality agreements when we are able to set precedents and go above what a company wants to pay. We get confidentiality agreements, and we do them all the time. But you need to watch, because you don't want to have confidentiality agreements that are too strict. Okay, so a landowner, this is very important. Landowner says, and this makes all the sense in the world, hey, if I'm getting a really good deal and the company is uncomfortable with this deal and they don't want the neighbors and they don't want other people in the area, they don't want you putting it online that you got so many feet or so many dollars per foot for a pipeline, or that you got a certain royalty percentage or a bonus per acre on your lease, and you're getting a good deal, and you're getting a good deal, and the company says, well, we want to have a confidentiality agreement so you're not out there blabbing this deal or putting this out there to other people, because then everyone's going to demand this same thing. And that can be very true. Here we go, the big H word. However, I say this almost probably every single week. The companies are very smart. This is not their first rodeo. They understand how to manipulate landowners. They understand that. They've been doing it for decades upon decades upon decades. We've seen it happen here, have we not? So what do companies do? Well, companies what companies will do, they'll give you, as a landowner, they'll present to you an offer. And as part of that offer, they'll say that they want you to sign a confidentiality agreement. Why? Because this is such a good deal, we don't want anyone else to know. So the landowner says, oh man, this is great. The company wants a confidentiality agreement because they're giving me such a good deal. Well, ladies and gentlemen, the company can use the confidentiality agreement concept as additional, what I call bait, for you as the landowner. So they want to bait you. They say, you're getting such a good deal, we need a confidentiality agreement. The landowner, not understanding the market or what's going on, says, wow, I must be getting a good deal because they want me to keep it quiet. They want me to keep it quiet, so it must be good. So Lana says, okay, let me just go ahead. I'm going to go ahead and do this because obviously I got a good deal. I don't need to talk to anyone. They're giving me a good deal. They need me to keep this quiet. Again, the companies know how to manipulate people. So they'll throw in confidentiality language to make you think that you're getting something special. To make you think you're getting something special. When in fact, you're getting maybe the same thing they're offering everybody else, perhaps even lower, but maybe the same thing they're offering everyone else. Think about this too. Say they're offering you lower. Say it's a situation where they're offering you $15 per foot for pipeline, and I hate to use that number because that's too low in my opinion, way too low. So say they're offering you $15 per foot for pipeline. And they say, we want you to sign a confidentiality agreement, which is insane. But they say that's what they want to do. Well, maybe part of that is, too, they don't want you talking to your neighbors or other people who they've paid $30 a foot or $45 a foot. So it can work that way too. Hey, my $15 per foot landowner, we're going to give you this, but don't tell anybody else because we don't want anyone else to know. Well, if you tell somebody else, they may say to you, well, I got $30 per foot. And you say, geez, why did I get so much less? Why did they get double me? So the companies can use confidentialities agreements to their benefit and put that language in these leases and in these right-of-way agreements. And I see this very, very often. In some of these cases, it's just routine. I see landowners out in Tioga County getting lease offers at 12.5% royalty that include confidentiality agreements. Why do you need to keep it quiet that you got the guaranteed state minimum royalty? You got the lowest possible royalty that can be given in the entire state of Pennsylvania, but they want you to sign a confidentiality agreement. Why? They don't want you telling people that you got the lowest possible royalty percentage that you could get. So you got to be careful. Confidentiality agreements can be very powerful. I have been involved in many cases. You got to watch because they have confidentiality agreements in them, but I've been involved in many cases where, as part of our negotiation process, I know the market. I've seen other cases. I know what people get. I know what other clients have received. I know what other landowners have received. And we know in certain cases that we're able to set the bar. We're able to break the precedent. We're able to go above what you normally see. Or we're able to get the company to pay for something they normally do not pay for. And in those cases, confidentiality agreements make sense for the landowner because you're getting something that the company truly doesn't want you to talk about or tell other people. That's when a confidentiality agreement is very good for the landowner. However, don't be fooled just because you're getting a confidentiality agreement or provision in your document. That does not necessarily mean you have something special. It can be used as a tool by the company to make you believe that you have a good deal when in reality you have the same as everybody else or possibly even lower. So when a company just comes from the opening bell and offers you a confidentiality agreement, don't get excited. There's a really good chance you have nothing special. However, when you negotiate, and normally it's even hard too with the landowner, but when you're negotiating and you truly have done something unique, you truly have gone to uncharted waters or into waters where few have traveled, then a confidentiality agreement can be very powerful for you. I am Attorney Doug Clark. This is All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. And if you ever need representation, you can contact me directly at 570-307-0702. That's 570-307-0702. And check out the websites at pagasleaseattorney.com and pipelineattorney.com. Remember, have the radio shows archived there, pagasleaseattorney.com. You can go tomorrow morning if you miss any of today's show, check it out, or any of the other shows. Okay, just to conclude here with the confidentiality agreements, another thing to watch out for. And I say agreements. Sometimes they're separate documents, or sometimes it's just an additional provision which is added to the gas lease or pipeline agreement or any other agreement or document. So what else we have to watch out for? Do not let these agreements be too restrictive that say something like you can't talk about this or give this information to anybody forever. It's just they're very restrictive. Well, what happens if you want to sell your property and maybe you have a pipeline agreement on there? And you obviously need to convey that to the person who you're going to sell to. You need to be careful. What if you're going to talk to your lawyer in the future? What if you're going to talk to a real estate agent? What about your financial advisor? When you say, hey, financial advisor, or your accountant, hey, I got this $500,000. The accountant says, okay, well, let's see the details. Well, I can't show you. I got a confidentiality agreement. Well, no, the accountant needs that information. We need to identify, or they need to identify. How is that classified? Is it going to be as damages? Is it going to be as compensation? What is the tax rate going to be for this money? So what I do is if we're going to have a confidentiality agreement, we have specific provisions indicating, or language indicating, who you can discuss this with. Another thing to watch out for, confidentiality agreements with, say, like a hunting club. I represent several hunting clubs, and they have a lot of members. Also represent properties that are held by large families. And so when you start getting a bunch of people to have this information, think if you have a hunting club, and I'll throw out a number, say it has 20 members. Are all 20 going to be quiet? Is anybody going to tell their wives, who are going to tell somebody else, or tell their husbands, whatever the case may be? It's really hard to keep that information confidential. So can that come back to bite you? Will it come back to bite you? These are all just considerations that you need to be thinking about. So we really try to avoid confidentiality agreements when possible when we're dealing with these larger groups like hunting clubs and families. And in fact, in most cases, we want to avoid confidentiality agreements, but in some cases, they can be a tool. Okay, I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. on these stations. And also, you can also follow me at Twitter at Doug Clark. You can follow me at Twitter at Douglas Clark at Doug Clark Law. So again, it's Douglas Clark at Doug Clark Law. Also, you can check out the PAGasleaseattorney.com. You can check out the Facebook. I do tweet articles and information. Sometimes, I'll be honest, sometimes I tend to be a little more active than others. But I think there is a lot of good information. I see something good. Anytime I read an interesting article, to me, I tweet that out. Also, I got people all the time, clients, landowners, who send me information. I filter that, say, hey, this is something good to pass on. So we pass that on as well. And then also, I have a newsletter, and we don't send out a bunch of stuff. I don't want to bother people. I know what it's like when I get all these emails with this junk mail. But every once in a while, I'll put out a newsletter. I'll do a blog for the website, and we'll notify people of that. So if you're interested in that, again, check out the website. You can send questions to the website. You can send radio show ideas to the website. Just visit PAGasleaseattorney.com. All right, I'm going to start here now. And I know already that I'm never going to have enough time for this, but I'm going to start. We're going to have my fun time where I'm going to talk about landmen, and I'm going to talk about a specific example, but this applies across the board. And unfortunately, I could do a whole show on this, but I'm going to start here and do it today, since we said at the beginning of the show we're going to get into this some today. Okay, so the landman. I know you're probably tired of hearing it, but I can't say it enough. The landman works for the company and not for you. The landman works for the company and not for you. Never, ever forget that. Most important rule, never forget that. So, okay, I have a client, comes to me, new client, says, okay, talking to this landman, sends me the information that the landman has sent to him, including emails and summaries of conversations and things of that nature. So I'm not going to get too specific, but I'm going to talk about some of this communication. And I'll bet if you're a person out there who's dealing with the landman now, or have dealt with the landman in the past, that this may seem familiar to you. Also, when I speak to new landmen that I've never dealt with before, it always cracks me up, because when they don't know who I am or know what my knowledge is, they think that I don't have any more detailed knowledge than the next guy. It's almost like they're reading from a script. It's the same stuff all the time after time. So I say to them, look, I do not mean to be offensive. I do not at all. But I just want to let you know that this is what I do. Every day, this is what I do. So we don't need to go through this whole spiel that you say to the person that you're speaking to the first time. Let's cut to the chase. Let's get to the details. Let's talk about what this deal is. Let's talk about what the leverage is, and let's see what we can work out. I don't need to hear all this stuff about how great this company is and how you're all about the landowner and all those other things. And again, I'm not being disrespectful. I don't say it disrespectfully, and I never would be that way. But let's cut to the chase and get to the details. Let's not go through this. Now, with the landowner, this guy or girl's knocking on your door or calling you. They're saying the same thing to you. Then they go to the next person, saying the same thing. I remember there was one guy, he was an Army Ranger, I believe it was. And look, I'm all for the Army Rangers, nothing about that. But what was interesting was every single person that called me that he contacted all told me, oh yeah, he's an Army Ranger, he's this and this and this. And they give me the whole story of his life. And it's just funny because Every single person that called me that he contacted told me the same exact thing. So they have essentially like scripts. It's like a presidential stump speech. They're saying the same thing to each person up and down the street. Everyone they're dealing with, they're saying the same thing. All right, I'm up against it. I'm going to save the good stuff here for the last segment. Stay tuned. You're listening to All Things Marcellus with me, Attorney Doug Clark, here every Sunday from 8 to 9 a.m. And once again, I'll be back after this last break. Welcome back to All Things Marcellus with me, Attorney Doug Clark, again here every Sunday from 8 to 9 a.m. on these stations. I'm going to jump right into it because I have a short segment. We're going to have some fun, talk about landmen. Okay, so landman, communicating with the client about the lease offer. Remember, the more desperate they are, the more desperate tactics they're going to use, meaning the more pressure they have. The worse, if it's a tougher offer to sell to you, they're going to use more aggressive tactics. So this is just some classic stuff. I wish I had more time, but this is all going to be good, so stay tuned, pay attention, because I'll probably talk a little faster than normal. All right, so it starts off, the landman says to my client, it's great to talk to somebody who's both intelligent and knowledgeable. I wouldn't say that unless it was true, because I don't say that to everybody. Okay, of course, they want you to like them. Remember, they don't send people out there to slap you around. They send people out there who you're going to like and say, oh, this is a friendly guy, it's a good guy. I hear that all the time from the landowners. Landman seemed like a good guy, really friendly guy. Yes, remember, he or she works for the company. Goes on then to say, I submitted all of these requests to my superior, to my supervisor, and unfortunately, you were not able to do these things, but here's the response. I've talked about this before. Here's what happens. Landman says, oh, yeah, that sounds good. We can probably do that. Yeah, that's reasonable, whether it's a pipeline or whether it's a gas lease. They'll yes you to death in those initial meetings. They'll say, yeah, okay. They endear themselves to you. You think, okay, this guy's on the same page as me. He's going to try to help me. He's going to go to his superiors and he's going to fight for me to get a better deal. Then he comes back and you don't get anything, or you just get get hardly anything. And it says, well, gee, shucks, almost can see the gentleman kick the ground. Oh boy, sorry about that. I really tried, but this is all the company will do. The big bad company, management, they all love to use that word, management, the company. This is all they'll do. So you say, well, geez, this guy was such a good guy, a nice guy. He was really helpful, seemed great, was really trying to go to bat for me. And if this is all we can do, well, I guess that's all we can do. Well, who does he work for? He works for the company. He works for the company. This is what they do. Landowner, you and I are friends. The second that landman says to you, I'm all about the landowner, then say, well, why are you doing this job? Why are you working for the company if you're all about the landowner? Then what you're telling me is you have a built-in conflict of interest and you're not an honorable person because you're not truly representing your employer. Should you not be representing your employer? If you were about the landowner, then why are you working for a landowner consulting company? No, you're about your job, which is fine. That's not a problem. Everybody has jobs. You want to make a living. We're on both sides here. Not a problem at all. But you as a landowner need to understand that. They are not pro-landowner. They are understandably, and you can't fault them for, they have a job and they have a job to do. Their job is to work for the company, not for you. So I'm tired of hearing I'm a pro landowner, I'm all about the landowner. That's simply not true. Okay, so next part, what they do is they say, yeah, this is a funny one. He tells the landowner, I have to keep reminding myself that the big money is in the royalties. I have to keep reminding myself that. Well, that's pretty funny. He has to keep reminding himself that. But isn't that very self-serving when you say to the landowner, oh yeah, hey, it's all about the royalties. Then, here's the other thing. Talked about this, gas prices. Companies, whether it be pipeline or gas, are preaching gas prices are low, therefore these numbers have to be low. Again, there's some truth to that because of budget concerns and constraints that companies may have. But the big picture, these wells and pipelines are going to be in place for decades. I just signed in the southwestern part of the state one of the highest compensation leases I have ever signed since I started doing this in 2007. One of the highest I've ever signed. So obviously, gas prices weren't the impact didn't have the impact on this deal. So, but it's very self-serving for the company to use that information or use that fact. When the gas prices are up, they're not saying, so if you go 2 years from now or a year from now and gas prices, say they're $8 per 1,000 cubic feet, are they going to say, okay, we're going to increase these offers by 4 times what they are? Heck no, they're not going to do that. So gas prices are a very nice tool for the landman and the companies to use to try to sell lower deals. Now, here's another thing that cracks me up. Companies say, or this landman says, there's even at 12.5% royalty, if the lowest possible royalty in the state, even at 12.5%, we're seeing landowners make a ton of money. There's some phenomenal wells. They're making a lot of money, 12.5%. You're still going to make out like crazy. This is a fantastic thing for you. This is fantastic. You're going to do outstanding. 12.5%, landowners are killing it. Well, think about that. If it's 12.5% and landowners are killing it, where's the rest of that percent going? To the company. So why can't the company afford to give me 15, 16, 17, 18? Well, of course they can. It's not just that simple where, we have other market conditions. You have competition to consider. And remember, this isn't individual advice, but the idea of if the landowner is making all this money at 12.5%, okay, then the company is making on the other 87.5%. Okay, so think about that. So it cracks me up, and this is just a funny thing to say to the landman. Well, okay, if I'm going to make all this money and these wells are so great, why can't the company afford to pay me some more? Because they're making all the rest of the money. So why can't I get a higher percentage, and see how they respond to that? Because that is the question, that's begged by that line of reasoning. I am Attorney Doug Clark. This is All Things Marcellus. We're here every Sunday from 8 to 9 a.m., and I'm blasting through here. I want to talk about some of these landmen tactics and what they do. Another thing is, and I got to be careful, I can't stress enough, this isn't specific advice, but I just find this funny, where they say, well, things can change day to day. It can change day to day. This offer could go away. Well, the offer could also go up. Example, Tioga County last year with Shell. Their offers were lower. So they said to everybody, same arguments. Hey, this could go away. This is all we're going to do. We're not going to go any higher. And then towards the end of the year, we saw a spike. And some of them, doubled in what the compensation offer was. Some not so much. Sometimes the percentage went up by 2.5 percentage points. Not specific advice, everybody, but understand these can go higher. It can also go higher. I am not telling anyone ever sit there and wait for it to go higher. And I'm certainly not saying that on this radio show. Ever, 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 never saying that. What I'm saying is you need to know your situation and make the right decision, getting all the facts, all the information, and make a calculated decision. But merely saying that this could go away, especially if you're offering the landowner minimum royalty, 12.5%, the lowest royalty you can possibly offer, you need to look at your situation as a landowner and say, well, you know what? Maybe I'll wait, because not only could this go away, but it could also go up. So you have to look at your situation. Again, I'm not telling you to wait. I'm very careful about that. But I want you to understand that, hey, there's another side to this. And this is where you need evaluation and consultation. Now, I'm going to say this, and this isn't meant to be a commercial, but I want to say something real quick. What I do a lot of times is I'll talk with landowners who have these lease offers, and they'll call in and say, hey, I have this lease offer, don't know what to do. So a lot of times we'll have this just a consultation, which generally at the maximum takes 2 hours, usually about an hour, and we'll go through the offer. We'll explain I'll talk about the pros and the cons, and we'll discuss, what is your risk tolerance as a landowner? Is this the right thing for you? And then sometimes landowners, after that consultation, will say, okay, you know what, I'm going to wait. or they say, you know what, I want to move forward, and they say, hey, will you represent me moving forward? This is no bait and switch here. They don't even have to hire me. They could hire somebody else or do whatever they want to do. But the idea is get the facts. Don't be afraid to call somebody, learn about this offer. It's a small investment, and the decision at the end is going to be a very important decision, and you want to make sure that you're making the right decision, an informed decision by somebody you can trust, not the landman who works for the company. So if you're in that situation, again, I'm sorry, I don't want to make it commercial, but this is so important. I've done so many of these, and every single one that I've done, the landowner has said, wow, that's great. I'm really happy about this. Not verbatim, but glad that they've done it because they now have a clearer picture and they're informed and can make the right decision for them. All right, I'm against it. I am Attorney Doug Clark. You are listening to All Things Marcellus. We're here every Sunday from 8 to 9 a.m. on these stations. Have a great week, everyone.